Good evening, everybody. I hope you can all hear me wherever you are. Thank you so much for coming along this evening to what I hope is going to be a really interesting discussion over the course of the next hour or so. My name is Michael Harwood. I'm the co-chair of the Employed Bar Steering Group at Middle Temple, and it's my privilege to be in discussion with Master Jonathan Jones, former Treasury Solicitor and head of the Government Legal Service. Over the next hour, I'm going to be asking Master Jones a series of questions about his career, some of the challenges that he's faced, reflections on the state of government and the state of the law and the interactions between the two. I'm hoping that will take up slightly over maybe the first half of this webinar, and then I'm going to open the floor up to questions from you, the members of the audience, and hopefully we can generate some really interesting discussion. I hope you've been invited to submit some questions in advance. If not, I'll be very happy to either take them using the sort of the hands up function or by putting them in the Zoom chat, and I will try and spot those and read them out for you. Before I do get started, just some obligatory Zoom etiquette, which I'm sure you're all very familiar with by now. You have hopefully all been put on mute. Can you please stay on mute for the duration of the webinar, just to avoid any interruptions from background noise, and we can then manage it when we get to the questions segment. So, by way of introduction, our guest, Master Jonathan Jones, was a civil service lawyer for over 30 years, his career starting out in 1989 at the Office of Fair Trading. He then progressed up the ranks and across various different departments, including Department for Transport, Her Majesty's Treasury, Department for Education, and the Home Office, before eventually being made Treasury Solicitor and head of the Government Legal Service in 2014. In taking up that role, he succeeded the late Sir Paul Jenkins, who of course was a former Master Treasurer of Middle Temple. Master Jones was made a Bencher of the Inn in 2007 and an Honorary QC in 2019. In that period as Treasury Solicitor, it would be no understatement to say that he oversaw some of the greatest and unique challenges in public life, including, of course, delivering on the Brexit referendum of 2016 and some of the unprecedented changes brought about in response to the coronavirus pandemic over the course of the last 12 months. On top of that, he also oversaw the creation of the Government Legal Department, which brought together what were previously a number of disparate public legal functions all under one roof. In September of last year, Master Jones resigned as Treasury Solicitor and head of the Government Legal Department as a consequence of the government's stated intention to break international law by reinterpreting the EU withdrawal agreement in the UK Internal Market Bill. So that's by way of a short introduction, other than to say, Master Jones, welcome, and thank you so much for joining us.
Well, thank you very much, Michael, and thank you to everybody for joining. It's a real pleasure to be here.
So I've got a few general topics which I wanted to cover you over the course of this discussion. The first of which sort of makes sense as an introductory topic, which is really covering what being a government lawyer is like and what it involves, because I'm sure we'll have many members of the audience who have quite a good understanding of that, but we may have many either because they are students or members of private practice who may have less of an understanding. So insofar as you're able to, I was wondering if you could start with just very briefly describing what are sort of the what is it that government lawyers do and are responsible for, and they're sort of their main functions.
Yeah, well, I'll try. It's a very good question, and it's not a straightforward one. And I'm sure that when I started out, I had no idea there was such a thing as a government lawyer, and really no idea what they did. So it's a career that in a way I came into a bit by accident. But it's been a great career and I've enjoyed it immensely. The work that government lawyers do is in one sense no different from that of any other lawyer. You give your client the best legal service you can, whether it's advice or whether it's conduct of litigation or handling specific legal topics. And you do that, you give your best, frank, candid advice, and you provide the best service you can. But of course, there's something a bit special about advising the government, partly because of the importance of what government does. So governments take the biggest decisions that affect the lives of every citizen. And of course, the breadth of work that government lawyers do is unparalleled anywhere else because it touches on every aspect of government and every aspect of life really in the country. And then secondly, governments are a bit unusual in that they actually create the law through Parliament, through primary legislation and through secondary legislation, regulations and so on. So part of the job of government lawyers is to draft and create new law. And that's the kind of work you can't do anywhere else. And then finally, of course, government is itself subject to particular constraints on what government can do, whether it's in the exercise of particular powers or whether it's in the control that the courts exercise through judicial review on the exercise of government powers. So there are particular special facets to the work of government lawyers and to the role of government in operating within the law. And I think that makes for a really fascinating and varied range of work. Equally, there are some things that government does that any other organisation will do. The civil service is an employer, so we have specialist employment lawyers, and the government enters into contracts. So we have commercial lawyers who advise on transactions and contracts and so on the government enters into. Again, some of those are no different from those any other organisation might enter into. Some of them, though, have much wider ramifications and are, some of the biggest transactions that anyone in the country enters into. So the range of work is very special. Some of it is unique, and it's all important work because it affects the life of the country and how the country is governed and every aspect of public services. So, and as you've said, in my career, I've done a fair spread of those things, and the community of government lawyers is now well over 2,000 people, most of them in the government legal department, but others in specialist legal teams. And it's a pretty special professional grouping. So that gives you an overview, I hope.
Thank you. Yeah, in my brief introduction, I gave a very brief overview of your career trajectory, which started at the Office of Fair Trading all the way through to Treasury Solicitor. I was wondering, in as much as you're able to give us a flavour of the types of things that you were advising on, and how varied they may have been across the different departments that you worked in.
Well, I mean, how long have we got? I'm condensing 30 odd years into a 3-minute answer, a bit of a challenge. Let me just say this. So that career spans different governments of different political persuasions, both Conservative and Labour, and of course coalition government. So you see policies come and go. And I said that government lawyers are like any other lawyer, they serve their client. And of course, as a government lawyer, you're serving the government of the day with its politics and its policies. And in the course of that career, I saw a Labour government that wanted to introduce major constitutional law change in the form of the Human Rights Act and the devolution legislation and Freedom of Information Act and various other constitutional reforms. It spanned wars in Iraq and Afghanistan. It spanned pretty big events triggering public inquiries, including the Chilcot inquiry into the Iraq war, of course, but also public inquiries into Grenfell Tower incident, infected blood, various other events, and of course I was part two of responding to the financial services crash, and so part of government is responding to events. Part of it is taking forward the policies of the government of the day. And actually, most of the things I've mentioned, one way or another, I was personally involved in over those years, whether the Treasury or in the Home Office or the Attorney General's office, and then latterly, of course, as Treasury Solicitor. So, I mean, that's just giving you a kind of flavour of the events that I've seen over the last 30 years, and therefore the sort of legal response to some of those things. And then latterly, as you said right at the beginning, of course, in my time as Treasury Solicitor, along came the EU referendum under David Cameron's government. And we all know that the rest is history. The rest is still history. The rest is current events. So you had the vote to leave the EU, and the whole of the civil service, including the government legal profession, had to pivot to respond to that huge constitutional and legal issue. And then at the end too, as you say, we had the coronavirus pandemic, and that again placed a huge set of new demands on the country, but also on the government and on the civil service, and not least on government lawyers, because so much of the response to that event has been legislative and legal. And some of those things might have been part of a government's plan, but quite a lot of them were not. Nobody'd heard of Brexit when I became Treasury Solicitor. Nobody'd heard of Article 50, and certainly nobody'd heard of COVID. So many of these big things that I've dealt with in my career, just came out of events, either political or unplanned. So that gives you, again, a bit of a flavour, I hope.
Thank you very much. As Treasury Solicitor, I think it's fair to say that you wore many hats, as well as being a lawyer, the government's most senior legal advisors. You were a civil servant, a permanent secretary, and head of the government legal department. How were you able to balance wearing all those various different hats at the same time?
Well, probably imperfectly, I'm sure. Nobody can perform all those roles perfectly all the time, and you learn as you go along. And different Treasury solicitors will have a kind of, or different leaders will have a different style, and they'll have a different way of how they focus their time. And I'm sure Susanna McGibbon, who's taken over from me, will have her own way of doing the job, and she'll, I'm sure, too, meet challenges, some of which none of us would have predicted. So to some extent, one is responding to events, and to some extent, one is just developing one's own sort of style of leadership. But for me, it was really important that I was still practicing as a lawyer and providing legal leadership, as well as leading the organisation that is the government legal department. And of course, you can't do everything yourself. Nobody can, no leader or manager can do everything themselves. And the trick is working out where you as an individual can add your own value and the things you get involved in personally, and where you, as a leader, create an organisation and create the systems and the structures that enable other people to do their jobs and to support you. And we may come on to this. Part of the reason for creating GLD in the form it now is was to create a stronger structure that enabled the whole system to provide a better legal service to government. And I think we at least partly succeeded in that. And of course, that then means I'm surrounded by people who are themselves expert in their field, who are themselves providing a great service, and then they can support me when I'm called on to play a particular personal role, whether it's on Brexit or anything else. I'm not doing it on my own. I'm doing it with the help and support of the teams and the structure and the organisation that I've helped to place around me. So you're right, it's a combination of things. and at different times, I might be personally involved in giving a legal advice. At other times, I will be overseeing the governance of a complicated organisation, and not all of that is glamorous. There are some, basic nuts and bolts of running any organisation that one has to do, and some of that, as I say, is putting in place the structures and the people around you to help. Those are the hats, and that's the way I saw the job. That combination of being a lawyer and providing legal leadership, but also helping to put in place an organisation and a structure that enables other people to provide a high quality service as well.
So my next few questions are really about something you touched on a moment ago in terms of the roles of a government lawyer, which is making law. Making and advising on the creation of primary and secondary legislation is one of the more unique things that a government lawyer is involved with, and it certainly marks them out from lawyers that really work anywhere else. You yourself, over the course of your career, were involved in advising on making of many laws, both as a junior and senior lawyer, I'm sure. I was wondering if you were able to give us a flavour from your experience, what are the ingredients of making good law, and then by contrast, bad law?
Yes, again, these are really good and very big questions, Michael. And yes, I've been involved in a few bills, and I've certainly drafted, I'd hate to say how many statutory instruments, most of which I'm sure have long been repealed or amended out of sight. Although I'm very pleased that one particular big SI I drafted when I was at the Treasury, the Regulated Activities Order, still survives as the basic structure for regulating financial services, financial instruments, although that too has been massively amended and added to over the years. In the end, the purpose of the law is to give effect to policy. So the better the policy, the more thought through the policy, the better the law. That's first point. Drafting lawyers, like any other lawyer, in the end act on instructions from their policy clients and ultimately ministers, which is another way of saying, if you have really bad law, normally the blame will lie with the client. That's another way of passing the buck. But of course, there are some other basic principles that apply. First of all, good law has to be accessible. It has to be available. You have to be able to find it and know what it is. Secondly, it needs to be comprehensible. Some law will have to be very technical. I don't mean necessarily comprehensible at a casual glance to the lay reader, but it does need to hang together and make sense. Not all our law does, I'm afraid, but that I would say would be part of the definition of what counts as good law. And it has also to achieve, as I say, the policy intention behind it, and it needs to pass the test of being used in the real world, because the purpose of the law in the end is to regulate behaviour and to achieve particular policy outcomes. And that in the end, that will be defined by how people behave, whether they obey the law, whether the law works, and whether the intention behind the law is upheld in the courts. Some law is more liable to be challenged in the courts than others, but I think if we're drafting a law, we're taking a view, how will this law be interpreted if it is challenged, if it ever comes before a court, either in public law or in private law litigation. And if the intention of the law is upheld, then that implies that it's doing its job, and that's good law. So those are all tests you might apply, I guess, to what makes good law. Some of that is easier said than done. It's all easier said than done, really, because we all know that the process of making policy is not a straightforward process of sticking a policy question in one end of a machine and the drafting comes out of the other. It's a complicated process. Even if the policy is relatively non-contentious, the process of developing policy and turning it into law can be very complicated. If the policy is contentious, then the process becomes more complicated, either in a straightforward way because amendments are added or concessions have to be given that dilute the purity of the legal structure, and politics can be like that. Politics is not pure. Or as we've seen in the legal response to COVID, if policy is being made very hurriedly, for reasons that may be understandable in an emergency, nonetheless, that's not an ideal situation for making good law. If policy is being made very hurriedly in a highly contentious, highly sensitive area, and then the drafting is having to be done very quickly, as I've said elsewhere, sometimes literally overnight, that may be necessary sometimes, exceptionally, but it's not really a recipe for making good law.
Thank you. In terms of lawmaking practices now, if we put aside for a moment both Brexit and the pandemic and the impacts they have had on lawmaking, it would still be right to say, I think, that the general trajectory is that the government or modern governments make more law now than they ever have done. I was wondering if you could explain to us why you think that is, and whether or not you think that's a good thing.
I don't know. I'm not sure if it's true. Is it? I mean, if you certainly the numerical terms, the response to Brexit and COVID have produced sort of huge numbers of legal instruments, statutory instruments, so on. So that is true. If you leave them aside, as you say, I'm not sure whether the volumes will be. I suspect the volumes fluctuate a bit. So I'm not sure. I don't have the stats in front of me. I mean, there is something about the business of government that provokes the creation of new law. It goes back to the fact that one has a government as a client. Governments like to do things, and they like to change things, and they would say they want to make things better. And we do live in a fairly heavily legally regulated world, where doing things and developing policy typically does involve legislation. I suspect there's not really any way out of that. And in a post-Brexit world, where being neutral on the pros and cons of Brexit, that's already produced an extremely elaborate legal order in the form of retained EU law and so on, and these hundreds of statutory instruments that we've mentioned. So you've already got quite a complicated legal framework as a result of Brexit. And then we have to assume that the government will want to do new things in exercise of its post-EU membership freedom, or by way of implementing the new relationship that it has now with the EU and the relationships it wants to have with other countries. So none of that seems to be likely to involve less law. So maybe we've just got to get used to it, that law as an instrument of making policy in a relatively regulated world, including a post-Brexit world, is just part of life. And perhaps that's fine because it means plenty of work for government lawyers. It's interesting work. And then the challenge, as we said, will be doing that in a way that produces good law and good regulation.
Looking specifically at the lawmaking that took place in relation to Brexit, there were, as you say, huge amounts of law that had to be made, and much more that just had to be drafted that were never made into law, just to cover all the various scenarios of Brexit. The thing that's always baffled me, and I'm sure a lot of other people, is where, as a legal advisor, do you start when it comes to trying to disentangle what is a hugely interwoven legal framework that we had with the EU, and working out what was going to replace it?
Well, I don't claim for a moment to have the unique right answer to that very complicated question. I do remember, I don't think this is giving anything away, just after the referendum results, when quite a lot of people were reeling, however they voted in the referendum. The result was a very big deal, and people were wondering what the hell do we do next. Partly pondering your question, where do you start? I had a meeting with Oliver Letwin, who was then the minister in the Cabinet Office, that was sort of who was David Cameron's chief fixer, and we pondered that very question. Elizabeth Gardner, first parliamentary counsel, was there too, I think, and we came up then with the model that, with many adaptations, actually proved to be pretty much what was done in the withdrawal legislation, which is to say you needed to provide for some continuity between this vast body of EU law, which was already part of UK law by virtue of our membership of the EU, into a post EU law, the EU membership world. You need to provide for that body of law to continue to be part of UK law up until such time as the UK government or Parliament wanted to change it. So that is in fact what happened. But equally, that would need to be amended to make sense for the time when the UK ceased to be a member. So you need to make adaptations. Even a neutral carry forward of that body of EU law would need to be amended so in order for it to work technically at a time when the UK was no longer in the EU. And that model held good. I mean, that's what we did. If anything, it proved to be more complicated than we'd ever assumed, because, well, maybe we should always have realised, perhaps we did, that the existing body of EU law was so complicated and so voluminous that it would need really a huge number of amendments in order for it to work, and that's where you get these thousands of SIs. But the basic idea that you'd need to have some structure to carry forward EU law into a post-EU world was held good, and that's what we had to do. But then, of course, on top of that, you had to layer, that was the neutral carry forward, but then you also had to give effect to the actual consequences of leaving, including the negotiation of the withdrawal agreement itself, the Article 50 agreement, and then this is really now after my time, obviously the agreement, the trade and cooperation agreement on the future relationship. So the whole thing was sort of most complicated sort of legal three-dimensional chess, really, involving both domestic law, including the body of EU law that was part of domestic law because of the European Communities Act, and then the new international law arrangements that we were entering into, both the Article 50 agreement and then the future agreement. And as I've said many times before, whatever view you take of Brexit as a policy exercise, it was a massively complicated legal and constitutional exercise, and so it has turned out to be. And I'm sort of pretty proud of the way that GLD and other government lawyers responded to it.
You touched a moment ago on the lawmaking that's taken place in response to the coronavirus pandemic. A lot of that law that it's been made is, it would be fair to say, exceptional in terms of both the level of restrictions it's placed on public life, but also the speed at which that it has had to have been made and the processes which it has had to go through in order to do that. What would you say was probably the most challenging part of transforming the legal landscape in that way? Its response was such a specific and some would say unpredictable incident.
Yeah, well, in a way, you've answered your own question. I mean, the fact that this was all completely unplanned for and massively urgent has placed huge pressure on all aspects of the public service and really all aspects of the economy and on all of us. And certainly the scale and the nature of the legislation that's been necessary is something that we would have thought we were dreaming if we'd imagined this. Well, just say 18 months ago, that we would be drafting and implementing legislation that prevented us from leaving our homes and that closed down most of the economy. So this is pretty extraordinary stuff. And I've spoken and written about this elsewhere. I mean, it is understandable that if you're having to do those things in an emergency, that some corners may have to be cut and that things may have to be done very quickly. And that, of course, is a challenge both to the process of making the policy. How do you make the right decisions if you're having to make them sort of against a changing picture of scientific evidence and at great speed? How do you make the right policy judgments when it comes to balancing the protection of public health with the impact on people's lives and on the economy? Those are really difficult judgments. It would be difficult judgments even if you had time for masses of consultation and all the usual processes. Where you don't, obviously that's extremely tough. And then the same goes for those responsible for drafting the law. The policy, we've said already, the policy drives the law, so the law then has to be drafted at high speed, infinitely complicated provisions, balancing these different interests, making exceptions for particular groups where that's necessary. All of that's produced a very complicated web.
It's publicly vilified for highlighting some.
Yes. And I think, again, I've said this elsewhere, that some of that is understandable, but equally, I think the government has got into some bad habits in the way it's responded to that, and for the default to be that legislation is made, that decisions are made at the last minute, and legislation is drafted at the last minute, and for the default to be that there's virtually no parliamentary scrutiny, or no scrutiny of any kind, really, is not good for the process of making policy or law. And for, again, I've said some of this elsewhere, for the law very often to come into force a matter of hours or even an hour after it's been drafted and finalised is not good for some of the tests that I set out earlier, for the law to be accessible and understandable and for people to know what applies to them. So I'm completely clear about what the challenges have been. And again, many people, including the lawyers responsible for drafting this legislation, have responded heroically to those challenges. But it's not a good template for how to make good law. And I hope that this will not become the default way, just because you can make law in this way, if you really have to in an emergency, that it doesn't become the norm.
So my next set of questions sort of fall under the category of what I call government and the courts. During your time as Treasury solicitors, there were the two, what I would call big pieces of Brexit-related litigation. You had the Article 50 challenge and the prorogation challenge, both of which went up to the Supreme Court. I was wondering if you could give everyone a flavour of just how much work is involved when you are litigating something, if just to take the Article 50 challenge for a moment, as significant as the mechanism by which the UK government can signal its departure from the EU.
Well, these are obviously massive cases, and they involve lawyers from across government, both litigators and advisors. And of course, both those cases ended up in the Supreme Court, and they were sort of epoch-making cases in their own way. So, yeah, they're a big deal. I mean, the other thing to say about them is, of course, they were both completely novel issues that had never been litigated before. And it's partly for that reason that they were so not novel legally and massively contentious politically and in policy terms. So that's the kind of magic combination, really, for big litigation. You have a novel legal point, a highly contested legal point, and the political stakes are very high and highly contested as well. So it doesn't get much bigger than that in terms of government litigation. In a way, if you take the Article 50 case, which you've asked me about, all of that said, it's a perfectly normal instance of a government position, a government decision being challenged, being plainly arguable both ways, and actually different courts finding different things. that's a sort of illustration of the fact that if judges are disagreeing with one another, it's pretty obvious that the point is capable of being argued both ways. So you have a highly contentious decision. The government takes a position, which is certainly arguable and defensible. The case is then challenged. It goes all the way to the Supreme Court. The Supreme Court finds against the government. On the Article 50 case, the finding is that primary legislation is needed to trigger Article 50 for reasons that are really completely unique and novel. So the government loses, and then the response to that is that the government does what the court has said it needs to do, which is get primary legislation and authority by an act of parliament to trigger Article 50, which is what it then did. So although it's a big case, controversial case, in purely sort of technical terms, it's just a JR going through the normal process, and then the government complies with the finding and does what the court says it needs to do, which is get primary legislation. And in its own different way, the prorogation case too, completely novel, difficult politically. I won't go into the politics of it, but arguable legally. So again, you've got the courts in Scotland and the courts in England taking a different view. Plainly, matters arguable both ways. And then it comes to the Supreme Court sitting the full court. So again, stakes don't get higher than this. So whether you agree with the outcome or not, somebody has to decide. And in our system, it's the court that decides what are the limits of, in that case, the prerogative power. And in the end, of course, the Supreme Court decided that Parliament had been unlawfully prorogued, and therefore declared that the prorogation was of no effect. So, in fact, in that case, there's no need for the government to do anything to comply, because the effect of the judgment was simply that the prorogation decision was set aside and Parliament was sitting all along. So these are big and really interesting cases, and of course they are a very big deal for the lawyers and the teams that are involved, and they will probably be cited in the textbooks and in the history of the sort of the Brexit years. But you can also see them as the system working as it's intended to work, the government being held to account by the rule of law, by the courts, and ultimately the government complying with the outcome.
These were, as you say, two cases which really captured the public and the media attention because of what they concerned. Do you think that those two cases in particular were more of a symptom of the particularly unique things that the government was doing at the time in order to deliver Brexit, or is litigation of that kind, big pieces of litigation challenging central government decision making, something that we're going to see more of in future?
Well, I think, as I've said, those two cases are both in their own way unique, and they are both very Brexit-y cases, obviously. And Brexit has been, for better or worse, the defining political factor, really, hasn't it, for the last, since the referendum, pretty much. And of course, that's been massively contentious in itself. So I think you can see, yes, you can see that litigation as being a reflection of the particular policy preoccupations and challenges that the government was trying to respond to in a sort of highly contested world. Obviously, post the general election, a bit less contested, as there was a clearer majority in the Commons for the Boris Johnson agenda. But in the end, the legal issue was just as contested. So I hesitate, I suppose, to draw too many conclusions from those two cases about what the likely trends are going to be. We know that there's currently a review, or there has been a review, an independent review into administrative law, into judicial review, which I believe is with the government. So this question of how far the government is held to account by the courts for its decision, what's the role of the courts in supervising and scrutinising decisions of the executive, that is a live issue that we'll wait to see. I don't know any more than anybody else what that review is saying. And it may well be the government will, has an appetite for reducing the role of the courts in scrutinising government decisions. But we'll have to see what the government says. I have my doubts about that. I think there is a kind of irreducible minimum role for the courts, which, well, we would try and tinker with that at our peril. And I suspect that any attempt to do that would fail, but you might want to come onto that, or we can explore that a bit further. But I've noted judicial review has its part to play, and will continue to have its part to play, I believe, in holding government and other public bodies to account for their decisions. I just hesitate to draw too many conclusions from the two particular cases we've mentioned. Totemic though they are, I'm not sure whether they really set pattern more generally for the future.
Thanks very much. I think at this stage, what I'll do is I'll start having a look through, because we've been sent in some questions by some of the attendees, and thank you very much to those of you who have been sending questions in. There's some really good ones here. I'm obviously very keen to make sure that we're able to put at least a few of them to you. So I will start with, I think, so the best place I think probably to start is the Master Deputy Treasurer of the Master McGowan has asked a question, which is if every outgoing Treasury Solicitor was allowed to create one piece of legislation as their desert island law, what would yours have been?
Oh, Master McGowan, that's very tricky. All right, I'm going to be utterly frivolous. Free cocktails for life for the outgoing Treasury Solicitor. If I can think of a more serious answer, I'll come back to it.
Great. Another question that we've had is how were you able in your role to stay out of the politics of things? You mentioned it was a multifaceted role with a requirement for many skills. Was the line not to be too political easy to see?
Not always easy. I mean, I think as a government lawyer, you're working in a political world. I mean, not everything you do is going to be heavily political, but the context is political. You're serving a government that is elected, that will have a political agenda, that wants to do things. And it's fundamental to the role of the civil service, including government lawyers, that it's the government's decision, it's the government's agenda, whether you agree with it or not, is not the point. It's the government's agenda that you're there to support. And as I say, I've worked for governments of all colours. So I've certainly never seen myself as being party political in that sense. And I think that's sort of part of the DNA of civil servants, that they get that. On the other hand, you also do have to get that you are working in a political context and that your clients are politicians, ultimately. The ministers you work for are politicians. And you do have to sort of get that, and you have to be on their side. You have to see what they're trying to achieve. Whether you agree with it or not is not the point. You have to sort of understand where they're coming from. And maybe sometimes that is a difficult line to tread, but it is sort of part of the fun of being a government lawyer, is that you are part of that sometimes messy political world, sometimes highly contentious, sometimes very controversial world. So if you're not everything one does is in that category, but some of the things you've touched on are highly political. It's your job to bring the cool legal analysis to bear on that and to give the frank advice, and you do that, as I say, whatever your own personal views. But you're doing that in a way that will resonate with your clients who are themselves politicians and want to achieve, political policy outcomes. So I would say, yeah, balancing that is not always straightforward, but it is part of it's kind of the part of the job, and it's part of the fun.
Another question we've had, which is not unrelated to that, is about what advice would you give to lawyers working with government departments or government bodies? What do lawyers need to bear in mind when they have a government body as a client, as opposed to a private sector client?
Well, part of it I've touched on. You sort of understand your client. Part of client care is sort of understanding your client and what they're trying to do and what they're trying to achieve. And so if your client is a government department, there'll be a particular answer to that question. Or client is a minister, they will have a particular agenda, which may be partly a political agenda, and you've got to understand that and be on their side. It's the job of the lawyer to be on the side of the client. And then there will be, of course, again, I touched on this right at the beginning, there's a kind of legal context within which governments operate, much of which doesn't apply to a private law client. That's the whole body of administrative law, the law that applies to public bodies and public law decision making, and very specific. The Human Rights Act will apply to public bodies in a way that it doesn't apply to most private sector clients. So you've got to be aware, of course, of the particular legal framework within which you are advising, within which your own particular minister or department is operating. So those are, I think, the two things. First of all, what's the law that applies, and that may be different in government. But also, what's the political context? What's the government or the department or the minister trying to achieve? And that may be different from, I'm not being too crude about it, but a private sector client whose motivation may be commercial, making money. Government departments will care about money, but they'll care about other things too. And it's just understanding where's your client coming from, what they're trying to achieve.
Thanks. Another question. During your time as head of the GLD, what do you consider were the key reforms to the legal teams to ensure the best legal decision making?
Well, as you said, part of my sort of aim and role was to help create the GLD and to create in one organisation a single legal service provider to government, bringing together all the teams that had previously been more or less separate. And there are a whole load of reasons for that. I mean, one was just to inject a bit more consistency and joined upness in the way that legal services were provided. The other was to become more nimble and resilient in the way we were able to move people around and deploy people. And thank goodness we did, because then along came Brexit and so on. And it was so much easier to organise people and to move people quickly than it would have been under the old structure. So I think some of those things led to just a sharper, more nimble legal service to government. But then there were specific things we did in GLD. Some of these now are sort of moderately ancient history, like creating the employment law group and the commercial law group and other specialist units that we simply couldn't have done under the old structures, because, sort of crudely I put it, you can do things with a single organisation of 2,500 people that you just can't do with 20 organisations of whatever it may be. You can organise them in specific ways, and that has helped produce vastly more professional expertise in particular fields, and a career structure in fields you want to be a specialist commercial lawyer. You can now do that in government in a way that you just couldn't have done before. So I think I can go on. This is my specialist subject, really, but and not all of this is glamorous. Some of this is sort of organisational change, and it's sort of winning hearts and minds and getting people to see the organisation in a different way. But I do think that it has delivered improvements of the kind I mentioned. And I do, again, to repeat myself, think that it made the response, both to Brexit and COVID, actually, demanding though those things were, it made responding to them that much easier than it would have done if we'd had the old, more fragmented structure.
Our next question asks, have you ever been involved in the making of law which saw a conflict between your legal reasoning and the government's intention in order to meet their political agenda? If yes, how did you resolve this conflict?
No, I don't think, not when it comes to drafting a law. I can't think of an example. Let's say in the end, the purpose of the law is to give effect to the policy. I mean, there will be occasions, particularly if you're drafting secondary legislation, where you're dependent on the powers of the parent act. The powers may not go wide enough to encompass what the minister wants to do. And I'm sure I've had examples of having to say, no, that's beyond the powers, you can't do that. But I mean, in the end, I think that advice would have been accepted. So I don't think it ever came to a full-on conflict. I can't think of an example where that conflict ever really crystallized. Of course, people will know that in the end, if a minister sort of insists on wanting to do something illegal, then there are mechanisms and escalations available ultimately up to the Attorney General for resolving those things. Aside from the drafting of a law, then I suppose, in the end, there's the issue that did cause me to resign, which I didn't resolve, which is the one you touched on right at the beginning in the Internal Market Bill. Let us hope that is a unique instance. We will see.
Thank you. Another question asks, how has the route into the employed bar changed since when you started through to now?
Well, I think and hope that the employed bar now is recognised more as an established, valuable part of the bar. And I think you and others probably on this call and Middle Temple take some of the credit for that. That there is more of a kind of status and structure to the employed bar as a part of the profession. That goes beyond government lawyers, of course, but I like to think that government lawyers are an important part of that. And I hope too that we are now better. I say we, so I don't feel I'm quite left. But the government as an employer, and GLD in particular, is now better at talking about what it does. As I say, when I came into it, I didn't really understand what I was getting into. I hope now there is a clear understanding of the importance and the value of what government lawyers, as an example of employed lawyers, do. And how do you get into it? Well, I think I might be saying, I've now been out a little while, that GLD is pretty much in continuous recruitment mode, which is a reflection of the volume of work there is and how much government lawyers are still needed. So there will be plenty of opportunities for the right people to get in. And as people probably also know, GLD offers traineeships. These are hotly competed for. I'm not saying these are easy jobs to get or traineeships to get, but they are very interesting and valuable roles for the right people.
So the next question sort of piggybacks off that really, and actually we've had a few questions very similar to this, so I'm just sort of combining a few together just to see if we can get through as many as we can. And it's really about what advice you would give to young lawyers either considering going into the public service or who are just starting their careers.
Well, I hope, notwithstanding the circumstances of my departure from it, I hope I'm giving the impression that it is possible to have a really interesting, valuable, rewarding career as a government lawyer. And I think if you ask many of my colleagues, past and present, that is what they would say in their own way. They've had really interesting jobs. So there's really interesting work to be done. It won't suit everybody. For some of the reasons we've touched on, you have to sort of get the idea of public service. You have to get the idea that you're working in a political environment where some things will be contentious and controversial, and you have to sort of get that and thrive on it. but for the right people, there is an interesting and varied and rewarding career there. And the other bit of advice I give is not to be too narrow about the way you approach that. So sort of be open for doing different things. One of the attractions for of being a government lawyer is the opportunity to work on different things throughout your career, different areas of law, different policies, different types of law. And I've got my own experience of my own particular career path, but plenty of government lawyers will have worked 3, 4, 5, 6 different areas, 3 or 5, 6 different client departments and so on. And that's a great privilege to do different things. But I would advise people not to be too rigid too early on in their careers about what they do. Be open to doing different things. I didn't really particularly plan my career, partly because I just didn't know what there was. So be open to spreading your wings and learning as you go, and not fixate too early on in your career. Don't try and micromanage your career too soon, I would say.
Great. And another question asks, do you think that legal advice given to ministers is now viewed as itself being political, for example, as being provided by someone who is maybe more likely to be a Remainer or a Brexiteer? Have you detected a change in these sort of perceptions? I suppose mainly since 2016.
Well, I hope not, I suppose. I mean, there's no doubt about it. We've said this, Brexit has been the defining issue for government, particularly the Boris Johnson government. And it was the drive, the one thing he was determined to do is get Brexit done. And, there was a sense if you weren't on side, certainly as a politician, then you didn't have any place in the government. And I think there is still a bit of suspicion of some parts of the civil service that not all the civil service was on board with this. And probably some of that applies to lawyers as much as to anybody else. And people have made assumptions about me, and I've been a Remainer, branded as a Remainer and so on. But my position on that has been sort of my own view on whether it was a good idea to leave the EU or not is neither here nor there. It was the government's policy to leave the EU. And that policy, the precise terms of our departure shifted as between Theresa May and Boris Johnson, and that's politics. And in the end, GLD and the rest of the system responded by delivering just the kind of Brexit that the government wanted, both in terms of domestic law and the international deal that was reached. And that's the deal we've now got. So in a way, whether any individual lawyer, including me or anybody else, is or was a Remainer is neither here nor there now. So in the end, I think, notwithstanding all of that, I hope and believe that lawyers have just stuck to their role, which is to give the best dispassionate advice, not always welcome, but that's the nature of legal advice. It's not always welcome. Give the best advice, do your best to turn the policy of the government of the day. In the end, it was the Boris Johnson government policy into the law, into the type of Brexit that was needed. And let's not forget that, important though Brexit is, there's a ton of legal work being done in government that's got nothing to do with Brexit. And there too, whether you're a Leaver or a Remainer is neither here nor there. What lawyers are doing is giving their best, frank, professional advice. And I hope that is what will prevail, notwithstanding all the turbulence we've seen around Brexit.
So we've got about a couple of minutes left until 6 o'clock, and in the interest of being punctual, I think I will maybe try and just squeeze in one more question that we've had from our attendees to finish on. And I think this is quite an appropriate one because it's sort of looking forward to the future, and it asks, what learning would you take from your time in the public sector into the rest of your career?
I hope I've learnt quite a lot about how governments work and how the Constitution works in terms of the relationship between government and Parliament and the courts and those important things. And I get the impression that they will continue to be important, if not more important, in a kind of post-Brexit, post-COVID world. So I hope I've taken some learning from those things. I hope I've also taken some learning from how organizations work and how people work with organizations. I assume this is why Linklaters are taking me on. That's the role I'm going to, is as a consultant with Linklaters. And I hope, I believe, I think that the reason why I'm joining them is because I do bring some of those, I do bring some of that knowledge and that experience, and that will now be of value, I hope, to both to the government, because of course Linklaters acts both for and against government and for a whole range of other clients, and that some of those things that I mentioned will be of value to either to government or to anybody else, any other client that wants to navigate the relationship with government, with legislation, with regulation, and that I will be able to use some of the things I've learned from that long career in government for the benefit of my new employer and its clients, I hope.
Thank you very much. Well, I can see it's now 6 o'clock. And so I, with apologies to those of you whose questions I wasn't able to get to, I think I managed to get hopefully through most of them. But it really just leaves me now to say a huge thank you to Master Jonathan Jones for speaking with me this evening, for answering my questions, but also everybody else's, for sharing his huge wealth of experience and knowledge and expertise, and in an area that we're continually trying to understand and get a better understanding of. I think, just speaking for myself, it was absolutely fascinating to hear all of that. So huge thank you to you, Master Jones.
Well, thank you for the really excellent and quite difficult questions, both from you and from the audience, if I can call them that. I don't feel I've done Master McGowan's question justice, so I will ponder and reply privately to you, Maura, about what my real favourite pet law would have been. But look, thank you, really, really great session and great questions. So, and thanks for coming and for inviting me.
Well, thanks to everyone for attending and for submitting your questions. And I hope you all stay safe and well. Take care.
Thank you. Thank you all.